This evening, after each variance request has been presented, this period is an opportunity for individuals to make a statement of opinion, not to engage in debate. Each speaker must state their name and address for the record. Speakers must be brief and to the point to allow everyone a chance to speak. Speakers must address the board as a whole, not individual members, and not other speakers or audience members. A professional demeanor is expected. Okay. Can I get a motion to accept the minutes of the last meeting?
I make a motion to approve the minutes.
And the second?
I second.
All those in favor? Okay. So, do you have a copy of tonight's agenda?
That should be next to top sheet.
Over here. Sorry. I got a lot of papers here, sorry, I got buried underneath it. Forgive me. Okay. We have no new business, so we're gonna go straight to my favorite people in the world, timely signs.
It's, I was, you can bring it home. You can tell my wife that. All this stuff. My name is Joe Biker. I'm from Timely Signs. I'm representing the ARC McHudson at 471 Albany Avenue to reappear with a newly designed monument sign with external illumination. I sent on the artwork for review along with some specifications showing night renderings as well as some lighting options for newly proposed hood.
Yeah, I took a look at this and we have copies of them in black and white here. I thought that this, now this is it top lit or bottom lit?
It's top lit.
It's just not showing the,
And if you go to the second page, it kind of shows how the illumination.
I'm
Want
looking
me to print it?
I'm looking at something else. I see, got it. Yeah, I saw this. And I thought that this, personally, thought this addressed the concerns that we were looking at wanting to address. I wanted to see if anybody else on the board, what their thoughts are about it.
So just to confirm, no part of this is internally lit.
And the changeable copy of it looks a little bit out of place because it's just an orange panel, but that's going to be, a color, some type of color rendering, some type of message.
So the whole panel just gets swapped out?
Gets swapped.
Yeah.
So the panel on the bottom, so you'll see like a small retainer, like an ivory band, you'd be able to change that from the side, or the stand, be able to change that from the side. So they'll be able to change messages, quarterly.
And this is on the existing concrete footings there. Yeah.
That's 2 LED wafers on each side.
There are some lighting specifications there. They do offer it in a variety of colors. We gave some specifications at the very end of the presentation showing what the LED fixtures are, and there's a light. There's some lighting options there in terms of 3,500.
Yeah. As long as it meets the lighting standards, and honestly, anything we do here is it could change that, and like, building department will still enforce the lighting standard. Now, on the type of variance that this is, did we land on anything official?
You have all the powers that the enforcement officer, zoning enforcement officer would have. If it's in a location which sign has always existed. I know the zoning enforcement officer did define this as a use variance being needed. A sign of this nature would be allowed, actually on the building. Theoretically, you could argue that, an area variance to allow for the sign to be located however many feet from the building where it's currently located, and granted under those terms, if you so determine that. It's hard to distinguish use when we're talking about, locations of signs.
Yeah, that's the
as
part
opposed
that,
to- Yeah,
I just don't know how this is a use variance.
and as I said, you guys can make a separate and different determination that an area variance would be required for said area variance, that it's within your powers.
yeah, I mean, I guess the only thing that I wonder is whether or not, this type of application has been challenged and there's like case law that would help guide.
I
I know it hasn't been here, but that doesn't mean it hasn't in another municipality.
Yeah, I'm not aware of any cases pertaining to locations of sign use variances.
I mean, signs, or there's a sign already there. They can just keep it and leave it the same. It's pre-existing.
Well, as long as they don't change, so that was my other question, right? So.
And the improvement they made to it is actually, it's better than it was.
I agree in every possible way, except for that the law says that pre-existing non-conforming cannot be modified in any way that increases the non-conformity. So the question, my other question is do we have the power to say that we can give a variance to the change in non-conformity, being that this is a pre-existing non-conforming sign, and all we want to do is let them make it be a teeny bit bigger, taller. It's the same width, right? I think almost, right? It's like just a little bit taller.
Well, square footage wise, it's really not bigger, right? They just changed the aspect ratio.
I mean, is it exactly the same or is it close?
It's very
It's
close.
really close.
Yeah.
We filled in the bottom space. There was a gap at the bottom between the monument and the start of the monument that we filled in. So I mean, in terms of square footage, you can measure from the bottom of the base all the way to the top.
That would be exactly the same.
Pretty close.
I mean, because if that was the case, then I'm just trying to figure out a way that obviously we're new to this, applying this in this way, right? So it's like, it would be great to get on the right foot and like kind of really know the best way to navigate this. I'm sure it's going to come up again, right?
Yes, well, particularly as relates to signs.
Yeah, so like in a situation like this, I mean, would we be able to say like that our interpretation under this presentation, if the height and overall width for getting the legs right there is the same, that we consider this pre-existing non-conforming that didn't increase the non-conformity because the size of the overall footprint is still the same, right? Like, could we just say that that's our interpretation and then?
That determination that we've determined that it doesn't increase the nonconformity and that therefore is in compliance with the code.
Yeah, I mean, you get where I'm getting at, right?
Yeah, no.
I feel like this should be fine, I just want to make sure that we're saying that it's fine in the right way.
I think if you put down, it's within the same footprint,
Yeah.
I think it can't be challenged.
There's a negligible difference.
Yeah.
It really is. Overall, it conforms.
Yeah.
In my sense.
I think I agree. I think that the way that this version of it in this space, I think, it fits what is there, it fits the intent of what was there, it's, I feel like we shouldn't necessarily be creating a barrier to this.
Yeah, no,
I just don't want to shoot ourselves in the foot.
I don't think that you shoot yourself. So,
If it was twice the size, we'd be looking at it,
Yeah.
or even the third again.
I think it meets all the boxes.
Yeah.
Yeah.
Checks all the boxes.
It's the legal box I'm
Yeah.
concerned about. So,
So my question, do you have the actual specific section for signs?
Oh, for sign, yeah, so I have the freestanding sign part here, which says that, it's really just the SD areas that it's allowed in.
What is this section? Just so-
Oh, this is, it's G of, 405, 40517. 517, section Q. And I think the non-conformity part is under administrative.
No, there's.
Or is that- or is that-
non-conformity that relates specifically signs.
Oh.
Health.
Here, wait.
Sorry. Whether.
So based on this, I think maybe we could say that we could, I just have to have this modified a little bit more to say that the exact dimensions in height, but that we could say that we consider this relettering, which would be acceptable under non-conforming.
Yeah, lettering, decorating, yeah.
Yeah.
I can say that you can find that this was a pre-existing sign at this location, and that there is no increase in the non-conformity, and that under section 40517L, we consider this to be a allowable non-conforming sign, considered to be permanently removed.
You could probably have an aspect ratio between rooms and square feet, and that would allow.
We, our contractor.
Oh, sorry.
So, sorry, we can't appreciate, yeah, but
Sorry,
thank you.
I was on board for 10 years.
Thanks.
Just trying to, sorry.
Do we know exactly what the difference in square footage is? It's like a matter of inches, right?
Yeah, if you want to put in approval to say that the height of the new sign will not exceed the height of the existing sign.
Yeah, you have the existing one is 48 by 44, is that accurate?
So it's 40, the top portion is 44 inches high, meaning from the bottom of the frame to the top of the frame. But if we say from the bottom or the top of the base to the top of the sign, assuming we don't go beyond what the existing sign is height-wise.
Yeah. Yeah, if we consider the relettering to mean from the concrete to the very top. If you can make it fit in that space, then we can consider this a pre-existing non-conforming sign that we're gonna call this
No
relettering.
variance.
And we can sit, and our determination can be that no variance is required because we're considering this relettering.
Absolutely. And we are actually using the existing posts within. So we're using a portion of that structure. So
Yeah. Is everybody, you guys get what the conundrum is here? Yeah.
So we will make
I got it.
the top of the sign, the new sign will match the exact top of that hood. In terms of like, it won't be any further or any more square footage taken out. It'll match that exactly.
Yeah.
So ultimately, they're not in need of variance under those
But you
guidelines.
guys will need to make that determination that, that basically under 40517L, determine that this constitutes a previously existing non-conforming signs, the proposed changes to the sign we consider to be relettering, decorating, and as such, we find that no variance is required.
To be fair, I don't think that, Eric may have looked at this version of it differently than he looked at the original version, so, so.
So do we have a motion?
I will make a motion to, so what are we gonna call this?
That the board finds that.
A finding?
Yeah.
Okay, we're gonna- I'll Make a motion to make a statement of finding that this complies to 40517L, existing signs and non-conforming signs. That we consider this relettering and decorating, provided that the overall dimensions of the complete structure are not exceeded what's there.
As
I'll
such,
second it.
as such, no variance is required.
And as such, no variance is required.
So we have a second, any further discussion?
No, all those in favor? You got us. Who was the second?
Carl.
Okay, all those in favor?
You code?
Are no other people?
Yes. Thank you so much. You guys have a great
Thank you.
holiday. Appreciate it.
You guys have any idea how difficult it is to write down like that?
No.
I'm not getting paid enough
I gotta remember,
to say that I'm not being paid anything.
I used to do that at other meetings, and that way I can listen back and keep retyping.
Gotta get otter or something.
That's what you. Okay, Susan's.
Yep.
Somebody's,
Users speaking?
well, these, they signed in. Somebody's got my pen. Anyway, I don't know if you need this.
I don't
You don't?
necessarily.
Yeah.
We're reopening now?
Well, we never opened it first time because,
Because of notification.
Yeah, yeah, so I mean, I'll, maybe I can open the public hearing on the second agenda. I don't know.
75 Clarendon.
Yeah. Even though we normally don't. You,
Do what?
motions for that? I guess because we waited last week or last month.
Well, do you need a motion to take it off the table since it was tabled last time?
Yeah,
Was it
it was
technically
tabled.
tabled?
It was, yeah, tabled, there was a motion to table it, because there was information that was missing.
Right.
So it tabled to this agenda for the public hearing.
So you don't need a motion to take it off the table?
No, you don't need a motion to take it. All right,
It's another thing, we really need to track down that guy Roberts. from the Roberts Rules. That guy strangled. I think he's dead though.
His book sales are good though.
Okay. So,
One second. So one second.
so we have a motion of a public hearing, it's now 6:25, and the public hearing in the application of 75 Clarendon Avenue, New York, applicant Paul Jankovich. So we have a motion to open a public hearing,
Who's making a motion?
I made it.
I'll second.
All right.
all in favor?
Aye.
Aye. Okay. So let's have the applicant, where's, there you go.
I'm representing the applicant.
You're, okay, but you're an attorney, so they get more time than you do.
He's an architect.
Oh, you're an architect?
Yeah.
Even less time. Just kidding.
So you're Paul, right?
Yes, Paul Jenkins, architect.
Wait. So my understanding is that the applicant's position is that this is a pre-existing residential use in this building that was at some point in the past approved and the building permit was obtained, and this is a legitimate residential use inside a commercial structure.
I can't speak for that. Okay, I talked to Scott Tutton, and she's recommended. And Scott said he developed the drawings for business use.
That is true, because I have them right here, and nowhere in this document is there a mention of a residential use.
So what I would like to proceed with it as a financial hardship for the tenant, not for the owner, for the tenant. The tenant has been there for a number of years. She has reduced rent, reduced utility bills. And if she was to relocate, excuse me, to another location, it would be a financial hardship, and that's my position on this. Now, the space is pre-existing. There is no changes to the building whatsoever. It's just a continuous use of the space by the tenant. So neighbors are not going to be impacted by this. It's pre-existing. If there are any code deficiencies, I'll go through the building department and rectify those deficiencies if something got overlooked years ago with the remodel for an office facility. And this is a mixed-use building, manufacturing, light manufacturing building as is classified. It's about 12,000 square feet of space, and this tenant space only represents a very small percentage of the overall space. Marie is here tonight. She's the tenant, and if you have any questions of her, she can give you a little bit of background. But my understanding is that, yes, this was built as office space. And it was never used as office space. She went into it and basically, when her husband passed away, and she's been in that building for that period of time. And approximately 3 years, am I correct? How many years? Okay.
5 years. So I just have,
Also,
I just have a question.
the zoning line is
Apply for a variance
So let's see.
under hardship.
Let's look at the actual wording, for these variances. And, you know, basically, at a reasonable return, so there's, four considerations.
It would have to be the
Well,
property
no,
owner, that's the
Yeah,
problem.
The tenant.
The tenant doesn't have standing to apply.
Has no return, yeah.
Right. The tenant has no standing to apply for a variance use or area other, that's the challenge here. It would be the property owner, as I understand it, unless council disagrees with me.
Well, I'm just saying, if we look at this even theoretically saying, let's take the standing question out of the picture. We know how difficult use variances are to be granted.
It's use of
Even
the
if-
space, right? So it doesn't matter, so the tenant can still apply, I mean, lessees of buildings apply all the time, that's fine. But they still have to say that there's no other possible permitted use that could give a reasonable return.
But also a reasonable return would apply,
Even if we were to grant her the status to apply for this variance, which I'm still a little iffy on, she wouldn't be able to meet the requirements for hardship.
Well, not the landlord, but the tenant.
The tenant
But
doesn't.
aren't we talking about with the new form-based zoning, trying to assist tenants?
Look, just so we're clear,
Yes.
I don't think there's a person at this table, I don't want to speak for anybody, but I think I'll go out on a limb and say, I don't think there's a person at this table that doesn't feel, that this is not easy, being that she's living there and she's been living there. That aside, we are trying to encourage with new form-based zoning, we have ADUs and all this stuff. But this is a situation where we're not even sure whether she's standing to ask for this use variance, number one. Number two, they just wouldn't be able to meet the use variance bar, which is very, very high. She would have to say as a tenant there that there isn't any other use, and she would have to prove it on paper with financials. There isn't any other use that she can't get a reasonable rate of return from. It's a bar that I just find highly unlikely that they could meet. And that would go for the owner of the building too.
So what I'm going to recommend is we have this application before us. Let's hear the arguments of the applicants. Let's hear, it looks like there's additional individuals here who want to.
Oh, yeah.
Heard in the hearing. And what I would recommend, since this is a unique situation, is that, upon closing the hearing, that the board not necessarily make a determination tonight, but make one at the next board meeting. And then that way, all of the potential issues, including the standing, the criteria under here, can be potentially discussed by the board and hopefully have something that is prepared in writing outlining all the bases for the determination.
Yeah, there's no way we'd be able to make a decision on this.
Is there
We'd have to-
any relationship, I don't know if this applies.
Just hold on a second, Dan. You'll have an opportunity to ask a question because we're about to get to that part of the meeting. So is there anything else that you want to share?
Yeah, this line arbitrarily is drawn, and on the other side of the driveway, not even roadway, is residential use. So we're not in an area that is, it's a stretch to permit this single residence to exist. It's contained within the building. The driveway is separating the basic uses, the difference in uses. And we have a person here who has a hardship, not the landlord has a hardship. The landlord is contributing to helping her, giving her, a low rent, taking care of some of the bills. So I don't, when we introduce the landlord or the property owner as the hardship, or he's got to claim the financial hardship that he can't get anyone else in the building, he certainly can get somebody else in the building. He's doing it for, he's helping out.
I understand,
Okay.
and I think that's a noble thing.
But you can't help us.
But we don't know that yet, but because we got to do some homework. But it's unclear right at the moment. So that's the reason why we're going to hear everybody out. And then we're going to do our homework and we'll make a determination based on what we find out between now and the next meeting.
Because we've invited all the neighbors.
Sure.
I think they're probably going to finish the whole public hearing, so anyone who is here to speak will have an opportunity to speak. Since you represent the applicant, you've got to speak first. If there's anything else that you want to say now, you can say, then they'll go through, let everyone else speak. Then if the board does want to ask any further questions of you, they will do so before they close the public hearing. But my understanding is probably once the public hearing is closed, what they will do before they deliberate, they'll basically adjourn and deliberate at the next meeting once they have additional information.
I think I've stated my case clearly,
Yeah.
and like now.
And we hear you. While you're still here, is there anybody else on the board that would like to ask the gentleman questions before we hear from neighbors and other? Okay. So what we're going to do is we're going to hear anybody who wants to speak on the.
I guess I do just want to confirm that, so
That was a
this,
delayed reaction.
yeah, it was. There has never been a permit for this to be an apartment.
Not-
All right, I just wanted to confirm that. Yeah.
The zoning enforcement officer came by and said they researched the file. There is no such outlet. And I believe that the tenant is going to come up and speak. So she can tell us, how it became an apartment. But, anyhow, you have the list of people who are gonna speak and take them in order.
I don't know, do it in order that they came in, or
Yeah.
do they want to just raise, I mean, raise the hand, I mean,
Who would like to speak first?
I think Joe, you know, that's, as the landlord, and maybe talk about the history and how this evolved, that Maria is now.
So when I bought the building, the previous owner, that's where he stayed. So according to myself, it's an apartment. It's actually pretty nice. Scott Dutton did his design.
So let's start with you telling everybody who you are and where you live and all that good stuff. So just for the record.
Joseph Percivalli, and I'm the owner of the building, 75 Betterman. And, yeah, when we bought the building, the previous owner, that's where he stayed. He lived in Connecticut, but when he came to Kingston, that's where he stayed. It was, as far as I'm concerned, as far as I know, it was an apartment. That's where they stayed. Scott Dutton did the design on it. I had no idea if it was an apartment, not an apartment. I had no intention of renting it as an apartment. When Maria lost her husband, which was a good friend of mine, said, we have a place here. She had 2 dogs at the time, hard to find a place to even afford on her own. And I said, come stay here. And she did. And she's been there for almost 5 years now.
Well, that answers that question. The former owner of the building put the apartment in, or
Just 20 years ago.
Yeah. Okay. Anything else?
No, I owned it for 8 years. And that's it. We don't want to put it on the street for sure.
Next person like to speak on this application?
Well, I can speak. My name is Jerry Duffy, and I'm
What's your
currently
address?
of 56 Clarendon Avenue, right across the street. My father-in-law was John Minervini. I don't know if you might have heard of Minervini or about it.
Yes, of course.
Well, my father-in-law died. My wife and I own the property. I've been working in business for 25 years. Okay, when he built the building, he built both the building we're currently in, which we do technical coatings, powder coating.
Yep.
He built the building with his apartment upstairs, all permitted, all zoned in and permitted. Right now, I have the property on the market, Greg Berardi is listing, but he checked it all out, and the apartment's legal upstairs. I mean, he died, and my mother-in-law died.
This is where your business, the powder coating.
Upstairs over my current business, right? He and my mother-in-law lived up there. And they built the building, and they built the building next, well, actually, the original building that I'm in now was a body shop. That was John Minervini Body Shop, original. And then he had a desire to start powder coating. Well, actually, he had a desire to open a steel shop. So he bought J Steel, and he built the building alongside of me, which is now owned by Suzanne Rowan Woodworking. They do high-end cabinetry and kitchens and woodworking. We subdivided the property with material, because it was all one piece. We subdivided it down the middle. We sold the woodworking business to Suzanne, and we're currently still working the powder coating business. But that was granted. But now, time-wise, I don't know, it was like 50 years ago when my father-in-law built the building. He was granted, approval for the apartment. So, I mean, if that sets a precedent, we're right across the street. I mean, and it's like, I don't really see where there's an issue myself, because it's zoned as residential and business. And, I mean, if I didn't know she was over there, no one else would know. And I'm in view. In my office, if I turn my chair around, I can see their building, and I can see where she parks her car. But I've only become aware of that just through conversation and about what's going on now. But you'd never know she's there. I mean, as far as I'm concerned, it doesn't affect me in
Okay.
any adverse way whatsoever.
Okay.
And I don't see where there's any problem. I honestly don't.
Okay.
I cut to the chase, but
Great. Correct me if I'm wrong, under the current zoning, is mixed use allowed at that location?
No SD, transects allow residential.
I didn't think so.
Yeah, so, if that is also an SD, that is also an SD.
But it
But
pre-exists.
if it was a fully permitted pre-existing unit, then it's pre-existing.
I built it under.
Yeah.
Is there anybody else here that would like to speak to this application? I know, Dan, you had something you wanted to say earlier.
Yeah, I had two comments. I represented the
So
seller.
Dan, right,
Oh.
just for the record, say who you are and where you live.
Okay, I'm Dan Lever. My primary residence is in Shokan, but I do commercial real estate. And I was involved in representing the seller, in Connecticut. And so I guess now that it's coming up, they called it an office, but if you go in there, if you were a building inspector, which was probably my cousin, but if you were a building inspector and went in there, there was no way that thing was an office. It has a gorgeous bathroom, showers, it's got everything. So Joe, not ever going to zoning and thinking of anything like this, he had an apartment because it was an apartment and somebody else lived there months on end. And so then the next thing I'd like to just say is that and every municipality is different. I was on some boards of municipality. One might say that we now have new zoning code and we have an overlay in Kingston. And the zoning line is the property line. So who's saying, so the truth of the matter is when we came into the form-based zoning, if he had gone to the meeting, they would have moved that line. We were all working at the Old Dutch Church going over it and all you had to do was make that comment. And they could have moved that line 1 foot and she would be legal. So now the question from the zoning board of appeals, you have use variances and all that. Now the question is, okay, so I get it. The truth of the law is that it was his responsibility to pay attention to the new zoning coming in and saying, hey, I got this apartment, can you move it to there? And they would have done it because they did all kinds of that. So the problem is he didn't do that and then
Okay. So I just want to be clear about something and correct me if I'm wrong. It doesn't matter whether it's new zoning or the old zoning. The apartment was put in illegally. It was never legal. And I get it. These things happen all the time. And sometimes they happen in very innocent ways. But the truth of the matter is that under the old zoning, and under the new zoning, it's just not allowed, but under the old zoning, they would have had to have gotten a building permit and applied for that permit.
there was a building permit. It's everybody looked the other way. From architect to building inspector.
I can't tell from the application, just under the old zoning was, like, if they had gotten a building permit, was it an actual allowable use under the old?
I don't know my book with me.
Well, I don't know book either, but it's possible that mixed use might have been okay there. And if they had gotten a building permit for residential use in there, and as long as it was built out with the proper, because oftentimes when you have residential and commercial together, there's certain fire break requirements and all that stuff. But the truth of the matter is that none of that was done. It's just this is not an uncommon scenario. But it's even more complicated now by the fact that we have new zoning and the new zoning doesn't really allow for that.
The goal of the form base was to increase affordable housing. And the mistake that's made here, which isn't necessarily fixable, was the applicant had the ability to go to these meetings, right, and make comment, because we move when we get up off Lucas Avenue, we move lines all over.
Yeah, moving of lines would have been something that would have had to have been addressed at the time
Yeah.
the transit zones were
So 2 years
created.
ago.
So, yeah, that would have been a whole
And to
process.
my knowledge, every property owner in an SD was individually consulted during this, so somebody from the development team reached out
Joe, did someone reach out to you for form-based asking?
Never, never.
Yeah.
And I know it was done by Scott, so, I mean,
Well, I think almost every property, I know every property owner in the city of Kingston was informed and was sent the letters about the new form-based code.
But the SDs were specifically, the SD zones were specifically engaged with on their own thing, because they're unique
When
properties.
they got lost in the sauce.
Yeah.
I think the big thing is that, yeah, I don't know if you can fix it, but the bottom line is if he'd gone there, they would move the line.
Correct.
But in
They're
that
pretty
case,
slick.
what you're referring to is the old zoning regs. If by the next meeting, if I research the old zoning regs, is that gonna make any difference at all if it was permitted?
No,
Not unless there was the CO of the space.
right.
Yeah.
Yeah, and the only reason I brought it up is that it just, this apartment was created in a way that did not conform to code, either by the old code and the new code. So that's the rub, that's the challenge.
This is, we're strictly asking for a use variance based on hardship. Going back to, it was originally the design that Scott Dutton had applied for was for an office use, B classification. So I want to make that clear, that we're not trying to
No.
fudge anything. It's just a hardship aspect.
Doesn't the plan show that he put in a shower?
I don't believe so. All saying that you can't have a shower in an office.
Yeah, written up for
It's a very sketchy, yes.
having those for that.
You're not really-
I mean, you know, it really doesn't necessarily matter what the plans are. If you don't have a CO as an apartment, it's moot. Nothing matters if you don't have a CO as it being your residence.
And then that asks is to,
Yeah.
how can we approach this? Is there some advice that the board can give to me as to the way I can approach this and possibly?
Yeah, I mean, you could petition the common council to change the zoning. I mean, that would be an option. You know, also, you know, we're supposed to do a whole review of this and see how it works, and maybe, you know, maybe we'll make some changes to the zoning. That's something that is on the table, but, you know, the common council is who does that.
Yeah, they're in charge of changing zoning.
Yes.
The reason why we have such a high bar with regard to these use variances is that we try to avoid, as does the common council, to be arbitrary and capricious about this. In other words, create what we call spot zoning, which is not an equal application of zoning.
so the one thing I would say is if you were going to approach the common council, I would do all your homework, find out first what the old code, if it was allowed under the old code, if basically, you know, there's no other like violations otherwise, other than the actual use, like everything else conforms to the code. And if you can show those kind of things, like as I mentioned, they'll check with the building department if they're going to consider that. And, you know, you wouldn't, like, they're not going to change it if then, you know, there's all sorts of other potential, you know, violations where it wouldn't be in conforming or be able to conform with the building code regardless. So I make sure that all those things are in order prior to sending a letter to, I reach out to, you know, your older person first and use them as a gateway to potentially get this before the common council.
And do we know how did this end up coming before us? Did code enforcement officers cite the property?
Yes. They did a survey.
I mean, large site, the total size of this lot is over 2 acres, right? Is it? Yeah, so you do have if you wanted to further develop the site, you do have an option to use the large site standards, in which case you could create whatever zoning that you want that's within a trend sector way, so you could make this whole thing T4, which would allow residential if you wanted to, if you were to develop the site according to the large site standards. But that would require, redevelopment of the site, but along with the intent of the code, if you did want to create affordable housing, or housing just in general, this site is an opportunity for that. It could be all T4 if you went through that process, and that's all in Article 7 of our code, but that is an avenue. So, I mean, if you really want to make places
Sounds
for
like
people
an
to live,
ambitious.
find a co-developer and build some buildings. Yeah, it's an option.
I have a quick question.
Yeah.
Would they address the code violations first or go with the zoning change?
Well, they can't address the code violation because they can't get a CO
Yeah, we're good.
as an apartment because it's not allowed by the zoning code. So they could fix it all and it could be an office, that's fine, but they're not allowed to fix it and make it an apartment because that's not allowed. And the only place that it's not allowed in the whole city is in these SD places, which, I mean, if you look at the code, they're all like unique industrial or like commercial spaces like the Kingston Plaza and stuff like that, you
Can
know?
I ask one before the attorney leaves?
Yes.
Okay, we have this existing condition. We have a tenant in the building. What is our exposure legally?
I can't give you legal advice. I can help guide you with our code if you're, tell you what potential options moving forward. I can't give you necessarily legal advice as to, what
I
you're,
mean,
Yeah.
I
the only legal advice I can give you is
We can
contact.
work.
To talk to an attorney.
Well,
I've got plenty of attorneys around me, but I'm just curious as to, is there, I mean, the city impose a fine, can I exist with that fine for a period of time? I don't want to throw her out at Christmas.
Well, generally, there is a requirement that you've been cited.
Yes.
They will give you a notice of violations in order to remedy and a certain amount of time to basically bring things. in
She's not
compliance
gonna
with the
be
codes.
asked to move before
If-
Christmas.
Yeah.
If basically it isn't brought into code within that time and they schedule a new inspection, generally there would be a reinspection fee if things are not brought into code, and they'll give you a new date for reinspection. The other thing that if you are written up for the violations, they can fine you, give you a appearance ticket, for road violations, and fine you. Generally, I don't know what the specific violation, but it is a zoning violation, is technically, it can be considered a violation each and every day. That is not in compliance with the code. But your best bet, other than talking to an attorney, is contacting the building department ahead of time if you receive the notice.
I have,
And, this is still pending here. So, you are making the efforts. Would be my understanding that the city is not going to be finding you each and every day while you're still in this process,
yes,
trying to see if it can be addressed by other means.
You're going through the right steps and the right
Yeah,
process.
You're doing everything
No,
that
the
you
city's-
can to try to bring
The
it.
city is not, and you're not gonna be punitive here, it's just gonna work through the process,
I want the tenant to feel comfortable, while we're going through this process.
Yeah, I've never seen circumstances where the city has evicted or done something to try to evict a tenant while there's some sort of pending application to address the non-compliance. And I don't
The
imagine.
city's goal is compliance, not penalties, right?
Yeah.
Yeah.
Appreciate it, thank you.
You're welcome.
Okay,
First, we have other members of the neighborhood here tonight, and as comments from the general public, we haven't closed yet, have we?
no, not at all, I had asked, everybody seemed to speak who
Why don't
wanted
you
to
just
speak.
say where you live?
Is there somebody else that would like to speak?
Well, I live basically across from Jerry on
Okay, so
Ted Davis.
introduce yourself and tell us your address.
Ted Davis, 51 Fireman Avenue. I've been there 32, 33 years maybe. Like I said, I've been manufacturing the Schultz's on it before. Previous guy had, trailer, and then he came from Connecticut, Bruce, and that, he would stay there, car dealer, and offices and whatnot. You really would not know that anybody was, so-called in there, staying there. As far as traffic wise, that, definitely no issue. The city doesn't plow our streets, so we're pretty much non-existent under that.
The city doesn't plow Clarendon?
No, they're supposed to plow.
Yeah.
They just get, they
They
run.
pull in and turn left instead of heading right.
Yes.
I live on a dead end too.
Yeah.
But yeah, I know, like I say, Schultz had it before. Don Swan had a cold storage on the other part, you mentioned the wall there.
Yep.
As far as for gaining, it's nice to know that someone is in the area. Jerry, fall into these two lights water, let light on, something going on. Certainly not a problem, a lot. Help out.
I just hate to see them going through this because they're good people. And, there's a lot of stronger issues that should be addressed in the city other than something like this. I mean, maybe I'm not saying it as I should, but I'm just cutting to the chase. I'm a real believer in common sense.
Well,
Maybe not Robert's Rules of Order, but common sense. What works.
the whole purpose of the zoning board of appeals is to actually, one of the things is to apply some common sense to the
Exactly.
zoning process.
Like if somebody were to try to put a
So-
residential up in the Kingston wall or
Right.
something, that'd be crazy.
Right.
But
But,
what this is, if you ever went and saw it.
Now, I did go and see it.
Oh, okay.
I think, you went over there. Did you go over there? No? You went,
I know.
right? Yeah, we usually go and visit these sites. Yeah, I mean, I'm gonna reserve my comment about the site. I mean, what I saw was not a lot of fun to look at, all the unlicensed vehicles and all that stuff. That could use some
I
cleaning
have
up.
a thing up on my fence to block that. There's a friend there, what's his name?
But,
Yeah,
so,
that should be addressed.
right, so, yeah, we're,
Look at my property, how neat I keep it.
no one is, yes, it looks very nice. I did notice that, when I went by there today. No one here is unsympathetic to this situation. Unfortunately, it was a self-created situation, by the former owner. You purchased the building and somehow or another title didn't pick up the fact that there was a violation, or you would have probably been alerted to that and it could have been rectified back then. So the problem with these things is things fall through the cracks and it just goes from one owner to the other and
So somebody has a vendetta.
until, well, no,
Right.
not a vendetta, but
Comes up,
no,
again.
you're done, okay? You spoke. It's not an
Right.
ongoing conversation. The problem is that things fall through the cracks. I'm in the real estate business. I deal with these issues all the time. And I've got a real estate transaction going on right now. It's a 3-bedroom, it's on the books as a 3-bedroom house with 1.5 bath, and it's a 4-bedroom house with 2.5 baths, and we are currently waiting, for that to be rectified because I flagged it, not the title company. We flagged it up front because we don't want to wait until the last minute to have to find this out and deal with it. So this stuff happens all the time.
Can I just give one last comment from,
I don't have one too, though.
okay,
Aside, I mentioned John Schultz had it years ago when he had storage, what have you. After that, Steve Rafferty had a furniture business there. He had upstairs storage, what have you, so I'm not saying it was like an attic or a loft. He may have had offices or stuff up there start working over, not saying bedroom area, bathroom, casual bath, I don't know about shower, what have you. I mean, the apartment that Scott did is phenomenal, but I think the building was there, Scott just upgraded it to meet code. Or Bruce, who came in from Connecticut, he
If
was
only it got the building. We would be here right now.
You just want to identify yourself and get on the record.
He did. Identify himself already. Oh, this gentleman here?
Yes, yes,
Oh.
please.
I'm sorry.
Leonardo Perez, I live on 55 Clarendon Avenue.
Okay,
I've been
55
there.
Clarendon.
Yeah, been there for 9 years.
Mhm.
And for myself, it's no issue to be having Maria there. So I'm very happy to she can stay there longer as can.
Well, it must be nice to have all these neighbors who are very supportive.
I love his kids and his
One family there.
we're all happy.
Well, we're gonna do our homework at this point, and we're gonna see about this issue with standing and what, if any, other possibilities. We rely a lot on Anthony. Anthony was instrumental from the very beginning and worked on all the working groups to create the form-based code. So he's really good at, he found that other option, which, and you're right, the city does have a goal to want to increase housing. However, they do not want to accomplish that through spot zoning. That is not the goal. So we're gonna look and we're gonna work and whatever the decision is, it's not gonna be made in an unsympathetic way. We have to make these decisions because whatever decisions we make become precedent. And then the next person that comes in here and says, I need to do this, and we say, you can't do that. And they'll go, well, you did it here, here, and here, so that's what we're trying to avoid. If we made every decision based on our own personal feelings and how much I like Maria and all that stuff, we'd have some real issues with our zoning if we did it that way. We can't do it that way, unfortunately.
So we come back next month or?
Yes.
Okay.
Yep.
So we'll keep this open.
Yep.
Well,
We're gonna table this until
well,
next.
why don't we, everyone else has spoken, we'll continue to close the public hearing, so we're gonna stay with that at least.
Yeah.
And then,
So, I'll take a motion from the board, to first for closing the public hearing on this.
Motion to close the public hearing.
I'll second.
First, Anthony second. All those in favor? Aye. All those opposed? So here's what we're gonna do. Like we said, we're gonna look at this, council's gonna look at this. And we'll have a determination as to how we're gonna deal with this at the next month's meeting in January. We are meeting in January, so. Yep, anybody wants to come back is welcome, obviously. And I want to thank everybody for their time and for their comments. I know this is a hard one, so. And we're not going to see one another before the holidays, so have a wonderful holiday.
Merry Christmas.
Merry Christmas.
I'll make a motion to close
Okay.
the meeting. To adjourn. Right, we're done.
Thank you. Thank you.
Thanks. Thanks for your time.
Well, seconded the motion to adjourn.
You're all out. Do you have a second for that?
Yeah.
Yeah, yeah. I was at almost every single one. Yeah, yeah.
We have.
I mean,
All those in favor of closing?
We're gonna do that, so.
Okay.
You guys have-
Um,
This is- Okay. Can
and
you give me your, so you're representing this, and I'll, you're the tenants.
I am.
I just wanted to.
I'll write it.
Are you the same?
The neighbor there, the eyeglasses also.
you're full stream.
Thank you.
Yeah, I mean, I don't know what the long-term plans are